My Saturday was nice and relaxed at least, so I was enjoying it quite well. And I'm sure tonight we're going to have quite a bit of fun. Last night was really, really fun. I enjoyed myself. And yeah, so this evening we're going to cover the other half of the prescribed book, which is to do with divorce, maintenance, and parental responsibilities. As I mentioned last night, this is just a reminder that I'm not covering every possible aspect or concept that's spoken about in the prescribed book. I'm just highlighting the parts that I think are important and that I've seen come up quite often in the previous questions that I've been adding to the mock exam site. So this is by no means an exhaustive class on everything that is possibly covered in the actual prescribed book. So I would recommend that you've read the book at least once. As I mentioned, I've read it probably 3 times now, maybe 4 times. And each time I read it, I do learn a bit more information. And sometimes the things that didn't make sense before make a bit more sense when you read them again. So definitely do read the prescribed book. Unfortunately, the study guide, there's just not enough information in there. I think to be able to pass the exam, it's very, very brief. I think even as exam prep, it's probably a little bit on the min side. So you would definitely have to have read the prescribed book at least once. So we'll be going through some things tonight, but if you notice I'm leaving some things out, that will be the reason why. Unfortunately, we don't have time to be able to cover every specific thing. So I've tried to focus on the parts that I have found to be more important, or ones that I found come up quite often in the actual exam questions. Right. Okay. If you have any questions, feel free to ask them. Just pop your hand up and then we'll get to your question as soon as we can. So you don't actually have to wait till like the end of the session or anything along those lines. Just pop your hand up and then we'll get round to any questions that you might have. The plan is to try and get through most of the points probably by maybe about 8:30, 7:30, and then we'll have about half an hour or so, or maybe 20 minutes or so to go through some questions. I pulled some questions off the mock exam site so that we can practice some questions as if they would appear on the actual exam. So I'm looking forward to that. I think it'll be quite interesting to go through those. But before we do that, let's just dive straight in and we'll start on marriages and that. If you can just keep your mics muted until you ask that question, it'll just help stop any feedback from coming through. All right, so our first one we're going to be talking about is the dissolution of a marriage, which is a fancy word to say that the person is getting divorced or the marriage ends via death. So those are the two main ways that the marriage would end. So I've got a couple of notes here with regards to the main ways that a marriage would end. Your first one would be that death of one of the spouses would automatically end the marriage. Likewise, as we were chatting last night, the annulment or the voiding of a marriage would also cause the marriage to come to an end. And then the last one would be by divorce. So those would be the 3 ways that a marriage would be dissolved. There is a section in the prescribed book where they talk about a separation. They list 2 types, a judicial separation, which they say is obsolete, so I'm not even really going to talk about that. And then they do mention extrajudicial separation. There are a few notes with regards to that. I'll just cover them quickly before we move on. Extrajudicial separation is where the spouses agree amongst themselves that they want to separate. This agreement that they have is only binding to the actual parties, the spouses themselves, and it doesn't affect any third parties. So any debt, any credit, anything along those lines, the separation agreement doesn't affect anything along those particular lines. So it's merely for the spouses to say, you know what, we need to take a break or whatever the case might be. Let's, each live in our own separate place. This would be what we would call extrajudicial separation. And even if they do agree to this, nothing stops a spouse from initiating a divorce or approaching the court for maintenance or anything along those lines. It's very much, I would consider, like an informal agreement between the spouses that, we need to I don't know, separate for a period of time to see if we can sort things out. There isn't much that I've seen with regards to questions dealing with separation, so I'll leave it there for now. If you are interested, there is a whole section that talks on that in the prescribed book, but that's about as far as I'll cover with regards to that. Okay, if we are dissolving the civil marriage by death, the consequences vary depending if the marriage was in community of property or out of community of property. They have different patrimonial consequences, and it is important to know the main differences between them. So in a marriage of community of property, a death of either spouse will terminate the marriage in that particular matrimonial system. The surviving spouse will automatically get a claim for half of the deceased spouse estate. Because remember, in community of property, everything gets pulled together and they are joint heirs, if you want to call it, of the estate. So when the estate dissolves, they each get 50-50. So when the one spouse dies, the surviving spouse gets an automatic 50% claim on that estate. The other 50% that's left over, that will then devolve on the deceased spouse's heirs, so their children, etc. The other 50% would go to them. What's also important to note is the money that gets claimed for the other spouse and also gets distributed as an inheritance, that's after all the liabilities and debts are paid for. So it'll be the net balance once that spouse's debt has been paid. So maybe they had a car loan or they had a cell phone, or whatever the case might be. Once all those debts are paid for, the surviving spouse will get a 50% claim against what's left, and the other 50% would then be distributed as an inheritance to that person's heirs. When it comes to marriage out of community of property, this is slightly different because the estates are kept separate. There's no joint estate. When one of the spouses die, only that spouse's estate is affected. Then the surviving spouse actually needs to put a claim in against the deceased spouse with regards to, like a claim for accrual, assuming their marriage system had the accrual. So it's not automatic. In community of property, it's automatic that the surviving spouse gets that claim, whereas out of community of property, it's not automatic, and the surviving spouse actually has to lodge a claim with the executor of the estate. So the executor is the person that will be winding up and handling the affairs of that deceased person's estate. If there is an accrual, what will happen then is that will be calculated before any inheritance is paid out. So they'll work out all the liabilities, the debts, they'll pay all those things, and then they'll see, okay, there's X amount left. They'll work out the accrual, and then once the accrual portion has been paid, whatever's left over will then be taken as the inheritance. The other matrimonial system that is used is the complete separation of property. Generally, in this matrimonial system, neither spouse has a claim against the other's estate when one of them dies. However, it is important to note that there is an option that a surviving spouse can apply for called a distribution order, and the court will only grant this if it's just and equitable. So it's not something that you can just rock up a court and say, hey, I don't like what happened, I need a distribution, or whatever the case might be. It's got to be just and equitable, and the contribution has to have been made to that deceased spouse estate, either maintaining it or improving the value of it. But we'll cover a bit more of that later on. Then with regards to maintenance, we have the Maintenance of Surviving Spouses Act, which gives the surviving spouse of that dissolved marriage a claim against the estate in case they need maintenance. So if the marriage dissolves by death, the surviving spouse can actually put a claim against the estate to say, you know what, I'm not going to be able to survive without that maintenance, because perhaps the other spouse was the breadwinner and was providing everything. So then the surviving spouse can actually put a claim in for maintenance so that they are able to carry on living even though the other person is deceased. Because obviously life is quite expensive, and if the other spouse was the breadwinner, then the surviving one's going to end up in a bit of a problem. But anyway, let's move on to our grounds of divorce. So these ones do come up quite often in the questions that I've seen, so it is important to know them. So the three grounds for divorce are the irretrievable breakdown of a marriage. This is covered under Section 4 of the Divorce Act. And then mental illness of a spouse. That's covered under Section 5 of the Divorce Act. And then the third ground for divorce is the continuous unconsciousness of a spouse, which is also covered under Section 5. So those three are important to remember. I have seen a couple of questions where they'll ask you, which one is not a ground of divorce or which one is a ground of divorce. So we just need to remember that the three grounds are the irretrievable breakdown of the marriage, mental illness, and continuous unconsciousness. So those are the three that are quite important. Then with regards to customary marriages, there is only one way to, besides death, the only other way to have the divorce or to dissolve the marriage would be the irretrievable breakdown. That's the only grounds that are listed for that, whereas all the others, there are those three options. With regards to the breakdown, they do ask a couple of questions from what I've seen with regards to the requirements for each of these ones. So very briefly, if you're going to stand on the grounds of divorce that there is an irretrievable breakdown, they do a test. The court will do a test to see if there is indeed a breakdown, and this is covered under Section 4.1 of the Divorce Act. So what they look at, the two requirements is the marriage relationship must no longer be normal, and there must be no reasonable prospect of the restoration of that relationship. So those are the two things the court is going to look at. So a person asking for a divorce on an irretrievable breakdown grounds would have to prove that, you know what, the relationship isn't normal and there's no prospect that this relationship can be restored. With regards to evidence, the court will accept evidence such as, the parties not having lived together for at least one continuous year prior to instituting the divorce, or perhaps that, the defendant has committed adultery and therefore, that trust in the relationship is broken down, or perhaps, the defendant has been, sentenced in court, so the other spouse could be, for instance, in jail. So those are all different reasons a person could put forward to say, you know what, the relationship is broken down and I don't think it's going to improve. With regards to the other grounds for divorce, which is mental illness, there has to be a reasonable prospect of a cure not being found in order to rely on this particular grounds. So they list three requirements with regards to relying on an incurable mental illness as a grounds for divorce. The first one is that the person needs to have been admitted as a patient at an institution. So they can't just be sitting at home, and have a problem. They actually have to be committed to an institution. There needs to at least have happened for 2 years prior to this divorce proceeding. So it can't be something that just happened yesterday. This has to be quite a prolonged circumstance. And the last requirement is there has to be no reasonable prospect that the person would be cured. So you can't just rely, oh, something happened 6 months ago. It's got to be over a 2-year period as a minimum. There's got to be no prospect that this person's mental illness could be cured. And on top of that, they also need to be in an institution for this sort of thing. So it's quite an onerous task to prove this particular one, but that is one of the grounds. The last ground that you can rely on for divorce is the continuous unconsciousness of a person. So in order to rely on this, that spouse needs to have been unconscious for at least 6 months, and it needs to be caused by a physical disorder. So this is different to the previous one. The previous one was a mental disorder. This one is a physical disorder. So perhaps maybe they were in a coma after an accident or something along those sort of lines. So it's a physical disorder that they've got. Important is that it needs to have been needs to have been in that situation for at least 6 continuous months before the person instituted a divorce action. And then likewise with this one, there needs to be no reasonable prospect that the person will regain consciousness. So very similar requirements to the mental illness, but this one is more to do with a physical component, a physical disorder. So those are the three different ways that a person can get divorced, or the grounds they can rely on them. But let's say, for instance, one of the spouses doesn't want to get divorced. They can then rely on what they call a defense against divorce action. So what would happen is that it would come before the courts. The one party wants to get a divorce because of, let's say, for argument's sake, the irretrievable breakdown of the marriage, and they prove ABC. But now the other spouse says, I don't want to get divorced. So they can then try and do a defense against this divorce, and they can try and rebut the allegation that the relationship has broken down. So they might say, you know what, there is a chance of reconciliation. Let's try and reconciliate, etc. And they've got to provide proof and enough motivation that the court can say, well, there seems to be maybe a chance that this could be retrieved, in which case the court will then put like a postponement on the divorce proceedings and allow for mediation to see if the couple are able to resolve their differences. However, if mediation doesn't work, that would obviously be a very strong indicator that the relationship in the marriage has irretrievably broken down, because even mediation isn't helping. So then obviously if they come back to court again, then the court would be obliged to issue a divorce because mediation has been attempted and failed. Does that make sense with regards to the different types of grounds that a person can rely on for a divorce? Are there any questions with regards to those grounds? All right, looks like we're all good. All right, so we'll move on to the patrimonial consequences. So patrimonial is a big fancy word to saying, i.e. the money side of things. So what's going to happen with our assets, our property, and our money? What are the consequences of divorce? So the patrimonial, and I'm going to keep using the word patrimonial because it's the correct word to use in this instance, and it's also good to practice that. So when you're talking to other people or you see it on the question, you know exactly, a patrimonial, I know exactly what that means. All right, so the patrimonial consequences depends on the particular type of matrimonial system that's been used, because each system has different consequences. So a community of property, this is one where all the assets are put into a joint estate. The surviving spouses are entitled to a 50% claim against the deceased's estate, because remember, everything gets put together. When one of the spouses dies, the marriage is dissolved and the surviving one is allowed a claim of 50%. That's community of property. Now, the other common system is the out of community of property, or a marriage out of community of property. And this will depend on what's in the antenuptial contract, as well as whether the marriage was with or without an accrual. So it's all going to come down to what did we agree to in our antenuptial contract as to how do we split our assets and who gets what. And then obviously, crucially, was the accrual system part of our marriage system? Because if there was an accrual, then obviously now one estate can claim against the other. We did cover quite a bit of that last night, so I just want to put a peg in there for now. So when it comes to the actual divorce and settling it, there was a lady last night that was talking about the settlement agreement, so we're just going to chat about that quickly now. So when a person gets divorced, or when a couple gets divorced, the actual patrimonial consequences of that divorce can be regulated by a settlement agreement. So a settlement agreement is when the two parties sit down together and they decide how they want to divide their estate out, and who gets what, who does what, who's going to pay for what, and so forth. Within this settlement agreement, you can include almost anything that you want to, provided that it's not something that's impossible, something that's contra bonus mors, or contrary to the Constitution or law. So it allows you a lot of freedom to decide how do you want to end this divorce, and who's responsible for what, and who has to sort out what. You can even, the settlement agreement itself doesn't even have to follow your specific matrimonial system. It will supersede that. So even if you have an antenuptial contract, if you have a settlement agreement and you agree to that, which is different to your matrimonial property system, you are allowed to do that. So you have a lot of freedom with regards to deciding how you want to end the marriage. If your settlement agreement is made in order of a court, and this is quite important, and I think even just from a general knowledge point of view, this is very interesting to know. But if your settlement agreement is made in order of the court, it becomes enforceable as a court order, which has some nice advantages, which we'll go into now. And if the settlement agreement is not made in order of the court, the agreement would then be enforced the same way that any other contractual dispute would be. You've got to go to court and you've got to enforce a contract, because essentially a settlement agreement is a contract. So if you don't make it an order of the court, if there is a dispute over something in there, you've got to take that party to court to have the court adjudicate on that settlement agreement to see who's right, who's wrong, and what needs to happen. However, if it is a court order, it makes it a lot easier to enforce it because it's now settled. This is what needs to be done, and you can have contempt of court, etc. Here's the main reason I'm saying this is quite interesting. It comes down to what they call prescription. So prescription is the fancy word for saying when does a debt expire. So debts that arise from a settlement agreement that are made in order of the court are therefore court judgments, and they're only prescribed after 30 years, and that's a very long time. If the settlement agreement is not made in order of the court, then your normal prescription or your normal period of expiry will apply, which is 3 years. So there's a huge difference between your 30 years and your 3 years if you're trying to claim back what is owed to you. So I thought that was very, very interesting. And it's something to keep in mind if you ever are thinking about getting married, or in this case, I suppose, divorce, which we hope we never get to. But a very interesting tidbit, or at least I thought so. With regards to the settlement agreement, you are able to rescind it, suspend it, or vary it depending on which route you've gone with regards to the settlement agreement. A settlement agreement is a contract, so for instance, it can be amended by mutual consent of both parties, unless of course you've got a clause in your agreement that says we are not allowed to do this. But assuming that's not included, you would be able to change some things. However, if you've made your settlement agreement an order of the court, then you can't subsequently change that. Because the court follows the functus officio, meaning the court has discharged its duty, it's made its decision, it's made this in order of the court, and it's not so easy to be able to change that because now it's a settled matter. However, there is a caveat, whereas if it is made a court order, you can still change some things with regards to guardianship, care, and maintenance, because that's allowed under the Divorce Act. But you wouldn't be able to substantially change very much else because that wouldn't be allowed. Does that make sense so far with regards to the patrimonial consequences of a settlement agreement before we move on to the pension side of things? Right, I'm not seeing any hands going up there. All right. Okay, so moving on from our marriage settlement, we are now going to talk about the pension interests. I've only got two little notes in here because I have seen this question come up. Pension interests do form part of a spouse's assets for determining the patrimonial benefits. In other words, when they get divorced and they're working out what the estate is worth, the person's pension interest does form part of that asset valuation. However, the key thing here is that this does not apply to marriages which exclude community of property. So your pension interest that gets included as part of your asset calculation only applies to community of property. If you got married out of community of property, then this wouldn't apply to that. And it's important to remember that distinction because I've come across a couple of questions on the mock exam where they do ask questions like this. They're very, very subtle. They'll just tell you that, so-and-so was married out of community property, and they'll give you all these numbers and everything else, hoping you've missed that first section, which said out of community or property, and then they'll ask you things about pension. So it's important to remember if it's out of community or property, the pension interest doesn't form part of the assets that are calculated for the divorce. But if they are in community or property, then the pension interest does form part of that asset calculation. Right, I've got one little note here with regards to trusts. The only time that it appears that the courts will be looking into including trusts or the assets that are hidden in the trust as part of the assets with regards to the divorce is if one of the spouses abuse the trust to hide their assets. In other words, I don't want to give these assets up in the divorce. I'll just put them in a trust to protect them, and that way I'll still keep them and the other spouse won't get them. If you do that, the courts will pierce the veil, as they call it, and they will assume that the trust assets are the spouse's assets and will include them as part of the divorce action. So with regards to trusts, if you abuse the trust to try and protect yourself from divorce, the courts may actually end up including those assets in the divorce settlement. With regards to a forfeiture of benefits, there's quite a long section in the book on this one. I have seen a couple of questions asking about this. I do want to run through this, as well as redistribution of assets. I do think it is quite important. So when it comes to the forfeiture of benefits, or forfeiture of patrimonial benefits, as the book refers to it, a court is able to order either a partial or total forfeiture of the benefits. So a forfeiture order may not be granted if the divorce is based on the grounds of mental or continuous illness. It can only be used if you're relying on the irretrievable breakdown of your marriage. So sure, it gets quite involved here. And I suppose very important now when you decide to get divorced, which way around you go and challenge, or which grounds you rely on. So if you want the other spouse to forfeit their claims, then you can't rely on mental illness or continuous unconsciousness. You have to rely on the irretrievable breakdown. But assuming the spouse went that way around, there are a couple of requirements in order to claim the forfeiture of benefits. The court will take into account the duration of the marriage, the circumstances which led to the breakdown of the marriage, and any substantial misconduct on the part of either spouse. Now, those three are important. I've seen one or two questions asking about it. They will ask you like there's four answers. Choose the one that's not taken into account with regards to forfeiture of benefits. So just to reiterate, the three grounds that the court, or the three circumstances the court looks into, are the duration of the marriage. In other words, how long did the marriage last? The circumstances which led to the breakdown of the marriage. And lastly, any substantial misconduct by either of the spouses. And it's important to note when they talk about substantial misconduct, it's got to be of a serious nature. And the examples they give include things like failing to provide financial support for the spouse or their children over a prolonged period of time, repeated adulterous relationships, domestic violence, etc. So it's got to be a serious the misconduct has to be of a serious nature. So that's the duration of the marriage, the circumstances which led to the breakdown of the marriage, and any substantial misconduct. Those are the three circumstances that the court is going to look into. An order for the forfeiture of benefits may only be granted if the court is satisfied that in the absence of this order, one spouse will be unduly benefited in relation to the other. And when they're looking at undue benefit, they're going to look at those three factors which we've just mentioned above. So it is important to be familiar with those three, because they can only work off those three factors. With regards to what benefits can be forfeited, the forfeiture of benefits is, I've just made a note in here for this particularly, it's not about losing a specific asset per se. This is about the other spouse losing their right to claim against your estate. So what happens is the court might say, right, spouse A, you have a forfeiture of your benefits. In other words, you can't claim against spouse B. So this could be quite an expensive thing if it is granted against a spouse. So it's not about them getting any or losing something. It's more about them not being able to claim against the other spouse. If your marriage is in community of property, the spouse against whom the court orders the forfeiture receives only the assets that they brought into the joint estate, unless, of course, they brought in more than 50% of the assets to the joint estate. They will then only get 50%. So they will obviously only be reduced down to that 50. If you obviously the smaller party here, you would get a lot more assets because you obviously didn't bring much in. With regards to what those assets are that can be forfeited, you're actually losing the right, for instance, they could say to occupy premises, or the premises where you are paying rent, etc. They'll lose the right to claim some of that over your estate. If you are out of community of property, you could lose the right to share in the accrual, for instance, or you might lose things that are in the marriage settlement, or any benefits that might be due to succession clause in your anti-nuptial contract. So really, the forfeiture of benefits means that the person loses their claim against the marriage estate or the other person's estate. So it's quite a serious thing. So it's not about them losing their own assets. It's about them losing the right to claim against the other spouse's assets. Does that make sense with regards to how the forfeiture benefits works? All right. Okay. The other category that they talk about is the redistribution of assets. There are a couple of prerequisites before you can invoke this. One of which is that the spouses mustn't have entered into an agreement regarding the division of their assets, i.e., there is no settlement agreement. Because if you make a settlement agreement, you've obviously sorted out how you want to divide your property and you can't rely on this. So you mustn't have had a settlement agreement, and you must have married subject to complete separation of property. So a redistribution of assets doesn't necessarily apply to all marriages. It's specific to the complete separation of property. And before you can claim it, there are a couple of requirements that have to be met. The first one is that the spouse who seeks redistribution must have contributed directly or indirectly to the maintenance of the other spouse's estate. And the court has to be satisfied that it is equitable and just to make the order. So those are the two requirements. The spouse must have contributed to the other spouse's estate increasing in value, and the court must be satisfied that it's going to be just and equitable to do that redistribution. Contributions, if you're wondering what the contributions are that they talk about, the contributions could be rendering services. So for instance, the spouse works in the other spouse's business without compensation, or perhaps for a very low salary. Perhaps that spouse saves expenses which would otherwise have been incurred, or, as they say, contributed in any other way, which is kind of a blanket for pretty much almost anything. But there has to have been a contribution that helped the other spouse's estate either maintain its value or increase in value. So there needs to have been a contribution somewhere. I see we have a hand up. Yes. Do you have a question with regards to the distribution of the estate?
Thank you very much. It's not in line to the redistribution of assets, but on the line of trusts. You mentioned that the court can come after a trust once they've identified that one of the spouse has used the trust to hide their assets. So what I wanted to check is how do they go about noting that this person has took some of their assets and hide them behind the trust? Because ordinarily what would happen is collectively we would contribute money into this trust, and then this trust will be the vehicle that will be purchasing all those properties. So is there a measuring stick which the courts will use to say, but this spouse has used this trust to either go about buying assets which were supposed to form part of this community of property in that regard? And I apologize for taking you back.
No, 100%, no problem. All right. So, as to how, I'll answer your first part of the question, how do they know? Well, the court wouldn't know. What would happen is the one spouse would have to bring this information to the court. So they would have to say, hold on, I know that my spouse has been doing A, B, C. I saw them put 2.2 million rand offshore in a trust overseas, or I know they had a house and they've now put it in the trust because they didn't want it to be part of the divorce. So someone, and most likely will be the spouse that's initiating the divorce, would have to say, you know what, I know there's assets that he's hiding or she is hiding in the trust, and would have to obviously bring the information to the court so the court is aware of it. Otherwise, the court wouldn't know what assets or what. They're relying on the parties bringing the information to them. But assuming one of the spouses did bring that information to the court and was able to motivate, you know what, we bought a beach house in Durban, but now all of a sudden I see the spouse has now moved it to the trust. They've done this because they wanted to hide that beach house from me so it doesn't form part of the estate, and I object. And then the court would obviously now have to look and say, well, is this what really happened? Or is this something normal? Was the person trying to hide the assets, or was this a bona fide transaction? So they would look at the circumstances of the transaction, the motives behind it, what it's being used for, and from that be able to decide, yes, the spouse is trying to hide assets by moving them into a trust, or they might say that, you know what, the transaction wasn't out of the ordinary and it had a bona fide cause. There was a case in the prescribed book where a similar sort of thing happened, where the husband moved things into a trust and the wife complained about it. However, the judge found, or the court found, that there wasn't any ulterior motives to that, because the trust was paying out to the children and his wife. So they were the beneficiaries. So the court said, well, he's not really hiding it because you are the beneficiary. So in that case, they said, there's nothing wrong with the trust. But there was another case where the husband had taken, I think it was like 2 million or something, and had taken that money out and put it into a trust to try and keep it away from the divorce settlement. And the wife said, hey, this is wrong, and brought the information before the court. And the court looked at the information and said, sure, this money was only moved 20 days before the divorce had started, and there were all these other transactions going on. So it looks like this person's trying to hide these assets from the divorce. And in that case, they pierced the veil of the trust, and they included all the trust assets as part of the husband's estate for calculating the divorce. So yeah, so it's going to be a two-pronged approach. Number one of the spouses has to bring this information to the court, so the court is aware of it. And number two, the court will look and see, was it a bona fide transaction, or does it look like the person's trying to hide assets? And then obviously from that, they would then work out, do we include those assets as part of the divorce, or don't we? Perfect. All right, so where were we now? Contributions, blah, blah, blah. Okay. Okay, so with regards to assets that can be considered for a redistribution, all assets that fall into a spouse's estate can be considered. So it's everything. It's quite a wide scope there. That will include assets that the spouse inherited or received, or any donations during the subsistence of the marriage. Important to note here is that a redistribution order can't be made against a spouse who's insolvent. So in other words, if you are beyond broke, and there might be a sequestration order, whatever the case is, if you are insolvent, meaning there are more debts and liabilities than assets, the court can't make a distribution order in favor of the other spouse. And also, generally speaking, the redistribution order could either be a sum of money. So the court might just say, well, I'm not going to move the assets, just tell me the value of it, and then they will then transfer that value to the other spouse. Or the court could say, you know what, there are specific assets you do need to transfer to the other spouse. So the court has a bit of leeway to decide whether it's going to be a physical asset, or if it's going to be money in place of that asset. But anyway, that's all I've got for redistribution of assets. If you want to know a bit more detail and whatnot, you can look it up in the prescribed book, but I've left it pretty much to those few points, as I think it sums it up easy enough. Once we've moved on from that one, our next point is to do with maintenance of a spouse after divorce. So maintenance in terms of an agreement between the spouses is one of the ways that they can resolve this issue. The spouses may enter into an agreement which covers the post-divorce maintenance. In other words, who pays maintenance to whom, for how long, and for what purposes. If they don't come to a maintenance agreement themselves, the court can also order maintenance on the spouse's behalf. So, for instance, if the spouses don't agree on the maintenance, or for how long, or for how much, or whatever the case might be, the spouse can approach the court, and then the court will make an order for maintenance. Generally speaking, the court will look at factors such as the spouse's existing or prospective means. How financially well off are they? Do they have an earning capacity? What are their current financial needs? What is the age of the different spouses? Can the other spouse afford it? And so on and so forth. There's a number of factors that the court will look into before making any particular order. So if the spouses can't agree on maintenance, assuming maintenance is needed, the court can step in. Sometimes there is no maintenance paid. It just depends on the particular circumstances of each couple's divorce. Uh, with regards to different types of maintenance, you get what they would call a rehabilitative maintenance. This is maintenance that is awarded to a spouse who has earning capacity, but needs to be retrained or trained to be able to get employment. So it's not for a prolonged period of time. Generally speaking, they say it's between 6 months and 18 months, although it does depend on each particular case. The essence of rehabilitative maintenance is to be able to tide the spouse over until they can become self-sufficient themselves. So the common example would be, if there was a wife who stayed at home and now they're getting divorced, she obviously now needs to earn money. So then they could set up a rehabilitative maintenance that could last, let's say, 2 years. And that would then help that wife get on her feet and help pay her expenses in the meantime while she studies or learns a trade or whatever the case might be to become self-sufficient. But rehabilitative maintenance does have an end, and its purpose is to help get the spouse on their feet and become self-sufficient. The other form of maintenance is what they call lump sum maintenance. And this is, as the name says, the spouse will get one large payment instead of perhaps continuous smaller payments over a period of time. You also get what they call token or nominal maintenance. The reason for this is perhaps at the time of the divorce, there wasn't a need to make a maintenance order, or perhaps the maintenance debtor didn't have the money or the finances at that point to be able to pay maintenance. What they'll do is they'll make a nominal maintenance award, maybe 10 Rand, 20 Rand, whatever the case might be. The reason they do this is because if maintenance is not awarded at divorce, it can never be awarded after that. So, for instance, if for example, let's say the person who's supposed to pay maintenance, the maintenance debtor, isn't in a position to pay maintenance. The maintenance recipient might say, well, that's fine. It doesn't have to be now. It can be later on when you paid your debt or whatever the case might be. So what will happen is the court will award a token maintenance. So in other words, there is maintenance, but it's a very small amount just to keep that window open so that when the maintenance debtor does get into a better financial position and can pay maintenance, the other spouse can go back to court to say we need to revise the maintenance amount up to what it should have been at divorce. Because if they don't get that maintenance order at the time of divorce, the spouse can never go back and ask for a maintenance order after that. So that's why they do the token maintenance. With regards to rescinding it or suspending or varying the maintenance order, any maintenance order that was made up in terms of the Divorce Act can be rescinded, meaning it can be cancelled, it can be suspended or varied if there's a sufficient reason for doing so. So maybe, inflation's gone up or there's been a huge substantial change in the financial position of the spouses. The other spouse could go back to court to ask them to vary it, suspend it, or rescind it, I suppose, if you were the maintenance debtor. Does that make sense so far with the different types of maintenance, the court-ordered maintenance, a maintenance agreement, the rehabilitative maintenance, and the token maintenance? All right. Okay, so now there is a maintenance. How do we terminate the maintenance order? So generally, a court can terminate a maintenance order by rescinding it, rescinding meaning to cancel it. Alternatively, if there's a settlement agreement, the terms of that agreement would then determine when the maintenance comes to an end. And important to note, as an insolvency doesn't terminate a maintenance order. So if you get a question in the exam where it says list one of these options that's not terminating maintenance, if there's insolvency there, we know that that's the correct one because insolvency doesn't terminate a maintenance order. Maintenance would be terminated if the person approached the court or if the settlement agreement put a specified time on it. The other option, for instance, is on the death of the maintenance recipient, because the death of that recipient will always end the maintenance because a deceased person is not entitled to maintenance. So if you do get questions, just look out for that wording, especially the insolvency one. I've seen a couple of questions. Insolvency doesn't terminate a maintenance order. With regards to the other ways to terminate a maintenance order, you can, for instance, on the remarriage of the maintenance recipient. So the Divorce Act has Section 7 subsection 1 and 2. So subsection 1 deals with settlement agreements. So settlement agreements is what the two spouses agree amongst themselves and how they're going to handle maintenance. And subsection 2 is the statutory foundation. So that's when the court makes the settlement order. And they each have different pros and cons. So with regards to remarriage, for instance, if you're under a section 7, subsection 1, it depends on what your agreement says. Does your agreement say that on remarriage, the maintenance ends, or does it continue? It'll depend on what your agreement was. But if your maintenance order is under subsection 2, which is the statutory court order one, maintenance will end on the death or remarriage of the maintenance recipient. So the maintenance recipient is the person that's receiving the maintenance. So it's also important to remember that remarriage doesn't include living in a life partnership. So if a spouse gets divorced and the court orders maintenance, if that spouse goes and lives with somebody else and they're living there permanently, that is not a remarriage. Even if they went to a minister and the minister so-called blessed their, and I'll put it in quotes, marriage, unless it's a registered marriage, that is not a remarriage and would not end the maintenance under that section 7 subsection 2. So if you get a question like that asking about a remarriage and a life partnership, just remember that a life partnership is not a marriage and will not end the maintenance under a section 7 subsection 2 order. Another way that a maintenance can end is by the death of the maintenance debtor. So when we say maintenance debtor, that's the person responsible for paying the maintenance. If you have a section 7 subsection 1, and the 7.1 is the settlement agreement, that there again would be determined by what the agreement says. So if the maintenance debtor terminates the duty and it's written in the agreement that it's when he dies or she dies, it comes to an end, it will come to an end. But if the agreement says that it will carry on for ABC, even if that person dies, the maintenance will carry on for ABC. So it very much depends on what was in the agreement as to whether the maintenance continues after the person's death or not, the maintenance debtor's debt. If they had a maintenance order under subsection 2, which is the statutory foundation one, the court order, maintenance will end on the death of the maintenance debtor. So that's a person paying the maintenance. If that person dies, then the maintenance ends. And there seems to be quite a bit of controversy over that versus the 7.1. If you want to read up a bit more on it, it's on page 204 and 205 of the prescribed book. They go through a couple of different cases, and the author also gives their position on why they think it's unfair. But from what I understand as it stands at the moment, the maintenance will end on the death of the maintenance debtor under the 7.2 maintenance order. Does that make sense with regards to the termination of maintenance?
Yes, it does. Thank you, Darren.
Ah, perfect. Right, we've only got two small sections left, and then we can jump onto some questions. I have some questions that I pulled off the mock exam site for the divorce and whatnot, so I'm quite keen to get onto those. But the last section we'll be going through tonight is with regards to interests of children during this divorce. There are a number of questions that do ask pertaining to this particular chapter, so it is good to know, and I pulled up quite a few points from it. So if you've done PVL 1501, you will remember that when we're talking about children, the Constitution in section 28 subsection 2 talks about the child's best interest being of paramount importance, and that comes out quite a few different places in this particular chapter. So whenever we're dealing with what is in the child's interests, it's always the child's paramount interests. So their interests are on paramount importance. I'm not going to list every single thing that's listed in there. If you really want to go through all the different rights and things that are ascribed to children, section 14.2 of the prescribed book goes through all those different factors that are taken into account when concerning what's in the best interests of the child. But as I say, it's quite a long list, and instead of me reading it off to you, you can go and catch up on that in the book. So that's section 14.2. It's got an entire list of what would be considered in the child's best interests. Moving on with regards to the divorce and the mediation side of things with children, The family advocate will be required to do an investigation if any one of these four things happen, and there are questions that ask this. So, for instance, if the care of a young child will not be awarded to the child's mother, if the siblings will be separated, will care be awarded to a person other than the child's parent, and are there arrangements regarding care or contact that will be made, which is prima facie not in the child's interests. Those are the four things that they're going to look for with regards to a family advocate doing an investigation. And there are some questions that will ask you, for instance, which one of the following statements best mentions when a family advocate would have to do an investigation. So what we'd be looking for are those four statements. The one is the child not being awarded to the mother? Are siblings being separated? Is the care being given to someone other than the parent? And is the arrangement not in the child's best interest? So those four will be the things that they're looking for with regards to the family advocate. So if you get questions regarding that, those are the 4 points that you need to look for in the answers. With regards to guardianship, there are a couple of questions where they'll ask you, what is guardianship? Guardianship refers to the administering and the safeguarding of the minor's estate. So that's to do with the patrimonial side of things, the assets that the minor has. Things, for instance, that would require both of parents' consent would be, for instance, the minor's marriage, application for a passport, removing the minor from South Africa, or perhaps selling immovable property that belongs to the minor. So all of this falls under guardianship because it relates to administrating the minor's estate. Those four that I mentioned, they are quite important. There are a couple of questions that will ask you that. So when will both parents' consent be needed? It's when a minor gets married, application for a passport, the minor's removal from South Africa, or the alienation, in other words, the selling off of the minor's immovable property. So immovable being that it's fixed property. So it's not a cell phone, a computer. It's like real estate. It's fixed property. So if there's any four of those circumstances, both parents have to give consent. You can't just have only one parent's consent. If a court, for instance, awards sole guardianship to only one of the parents, that parent then becomes the child's only guardian, and they can then give consent without anybody else's need. So, for instance, if there's a spouse A or parent A and parent B, and parent A gets sole guardianship over the child, parent A can go and get a passport. Parent A can consent to the child's marriage, etc., because they have sole guardianship. But if they don't have sole guardianship, then both parents or guardians need to give consent. So that's the only caveat with regards to requiring both parents' consent. The other thing that they talk about with regards to children is care. And I've seen a couple of questions that they'll ask you, what is the definition of care under the Children's Act? Well, the definition of care under the Children's Act means to provide the child with a suitable place to live, to safeguard and promote the child's well-being, protecting the child from treatment, maintaining a relationship with the child, and so on and so forth. There's quite a few of them. If you want to read up on all of them, you can go to the Children's Act section 1, subsection 1. It lists a whole string of different things that are defined as care. But I mean, it's really coming down to protecting the child from abuse and neglect, safeguarding them, etc. The other concept they talk about is contact. Now, contact refers to maintaining a personal relationship with the child. And if that child is living with somebody else, constantly being in communication with them. So on a regular basis, communicating with that child. Maintenance is the last one that they talk about with regards to children. When they talk about children and maintenance, what they mean is providing for the child. So for instance, providing food, clothes, accommodation, medical care, education, so on and so forth. That would be maintenance of the child. So just to recap, under the interests of the children, we're going to have guardianship, which refers to administering the minor's estate. We're going to have care, which talks about looking after the child and safeguarding the child. You're going to have contact, which refers to a personal relationship with the child. And you're going to have maintenance, which means providing for the child. Those topics do come up in the questionnaire, so just be aware what each one covers. Before I move on to parental responsibilities, which is the last section we've got for tonight, does anyone have any questions with regards to the interests of children or anything along those lines that we've covered in this section? All right, it looks like the last set of points I have for tonight is the last chapter in the book. It talks about parental responsibilities and rights. Now, there are a number of questions that will ask these particular points, so it is good to be familiar with them. So the first one I've got here there is requiring or acquiring parental responsibilities and rights. There are a number of questions that deal with this in different ways. So how do you acquire parental responsibilities and rights? The first one is birth. So a child's biological mother automatically acquires parental responsibilities, and the exception to this would be if it's a surrogacy. So if a woman is birthing the child or gestating the child and birthing the child for an adoptive parent or commissioning parents, that woman wouldn't get parental responsibilities because there's a surrogacy agreement in place. The other way that a person can get parental responsibilities, now most of this is geared towards men, because obviously if a woman gives birth to the child, she automatically has those rights and responsibilities. So the rest of these refer mostly to men. So for example, a marriage or a civil union at the time the child was conceived or born. So if a man is married to a woman when the child is conceived or born, that father automatically acquires parental responsibilities and rights. If there is a permanent life partnership that existed at the time of the child's birth, the father would also, in that case, automatically get responsibilities and rights. Likewise, if the father acknowledges paternity, well, obviously there, in that case, you will get those responsibilities and rights. If an unmarried biological father, they can acquire parental responsibilities and rights by entering into or accepting parental responsibilities and rights. So this is where the person is a father or they're the parent of the one child, but they don't have responsibilities. One way that they can gain those responsibilities and rights would be, for instance, looking after the child, paying a maintenance, trying in good faith to support that child. All those things will add to that person's ability to acquire those rights. I haven't listed all those specific points in here, but there is that section there that talks about it in 21(1) of the Children's Act with regards to the particulars that he gets. But generally, it's to do with the father supporting the child in maintenance, or at least in good faith trying to support the child. Another way that a person can get parental responsibility is if a court assigns a person those parental responsibilities. You can also have, and this is quite an easy one, I think, to remember, adoption. So adoption confers full parental responsibilities and rights on the adopting parent or parents. Yeah, that's pretty much it. So it's adoption, it's assignment by a court, it's a birth, for instance, for the mother. It's the father if they are married together, or if the father marries at any point after that, or if a man tries to pay support and maintenance towards the child's upbringing and care. So those would all be ways you can acquire it. Now, there's also a number of questions asked. How do you terminate parental responsibilities and rights? And I've seen on the system that this one seems to catch quite a few people up. It's actually flagged this question for me to check. It says that a lot of people are getting this particular question wrong. So how would you terminate parental responsibilities and rights? So under your prescribed book, they list a number of reasons. The first one is the child's death. Now, as we mentioned previously, a deceased person can't claim maintenance. So the child's death gives you an unqualified termination of parental responsibilities. The other route is the child's adoption, because now adoption terminates all parental responsibilities that existed prior to the adoption. And the child becoming self-sufficient. That obviously is self-explanatory. If the child can look after themselves, they no longer need to rely on the parents. And the last one was the child entering a marriage. And I put this one at the end because there's a qualification with regards to this one. The other three are what I would call unqualified. Marriage, the child entering marriage is a qualified exception here. And the reason I say that is that when the child enters a marriage, the duty of support rests with the child's spouse. However, if the child's spouse cannot support the child can still go back to their parents to claim maintenance. So that's why I call this one a qualified exception, because if the child spouse can't support them, they can go back to the parents to claim support. So although we say that the child getting married does terminate the parental rights and responsibilities, this one is qualified because the child can always go back and say, you know what, my spouse can't afford to maintain me, etc., and I'm making a claim against you. So if you get a question along those lines and they put a couple of these ones in, if you are a bit confused, just remember that entering marriage is not an unqualified exception. The only ones being would be the child's death, the child's adoption, or becoming self-sufficient. Marriage has that caveat of if the child's spouse cannot afford the maintenance, that child can then go back and claim it from the parents. Important to note here as well, insolvency doesn't absolve a parent of their duties to support the child. Same as with regards to paying maintenance, insolvency doesn't affect the maintenance debtor. In this case, insolvency doesn't affect the parent with regards to the duty to support their child. Whether you're insolvent or not, you still have that duty. And my last point for tonight is to do with parenting plans. It's a very short point because there is a particular question that if you've done the mock exam a couple of times, I'm sure you would have come across it. It asks about parenting plans and who are party to these parenting plans. And the answer in this case is fairly easy. When you're preparing a parenting plan, you have to seek the assistance of your family advocate, a social worker, or a psychologist. So I'll repeat that again. When preparing a parenting plan, you've got to seek the assistance of a family advocate, a social worker, or a psychologist. So as long as you can remember those three, if you get this question, you'll be able to ace it. Because I know the question throws in all sorts of things like attorney and court advocate and all different things. All you have to remember is it's an advocate, social worker, or psychologist. And that is all my notes done for tonight. I don't know if anyone has any questions with regards to the termination of parental rights and responsibilities or acquiring them. If there are, maybe we can answer those questions now before we move on to the mock exam questions that I took a screenshot on that we can work through. So yeah, does anyone have any questions with regards to this last section?
No question from my side.
Just as we hit our last question. Awesome. You can unmute your mic and go for it.
Okay, I have a question now. I'm not married to this guy. I fall pregnant, we have a baby, and this guy is not supporting this child. Okay. So, on my will, I actually note that can this person not take my child when I pass away? Will that be void? Will that be valid?
All right. You can do guardianship appointed in a will, but you have to have sole guardianship. So if there's another parent involved, yeah, so for instance, let's say the father's around and he has parental rights and responsibilities, then you can't do that. It would be void. But if you were the only guardian, so let's say you were the sole parent with guardianship, then yes, you could do that. You could appoint somebody else to take guardianship of the child. So it would depend if there is another guardian or another parent who has rights and responsibilities.
Okay, yeah.
Awesome. Any other questions with regards to acquiring rights or losing rights? Hey, Sean.
Hey, Darren. Hello, everyone. Yeah, just on the previous question, I just want to latch on to what Darren said with regards to the interest of the child. So say it is stated in the will and say you do have sole guardianship of the child, but I don't know, sometime down the line, it turns out that the father is reformed and, in fact, is in a much better position to provide the child with safety and education than whoever else may be the current guardian. I think then perhaps the court may consider the best interest of the child, in spite of the will.
Yeah, so any party that has an interest in the child can approach the court. So as Sean says, there may be another party that the court might say has a best interest. But this is all predicated on whether that parent has sole guardianship or not. And it's really going to come down to that. If the parent doesn't have sole guardianship, then there's no basis to be able to appoint someone in a will. If you are the sole guardian, then you would obviously have that standing to be able to appoint someone. But then, as Sean points out, if there is another interested party who has an interest in the child, they could challenge that. Whether or not they'll be successful, obviously, would determine on the circumstances and the court. But it is conceivable that the court might actually award guardianship to somebody else. The High Court is the upper guardian of all minors, so they do have the final say. So it is possible, even if you had sole guardianship and in your will you made your friend the guardian, perhaps the grandmother or somebody else in the family challenged it, it is possible that they may get guardianship. But obviously, this is all assuming that the original spouse was the only one with sole guardianship. All right. Do we have any other questions or comments with regards to acquiring or terminating parental rights? Oh, no questions. All right. So you guys want to, I see we are, hey, how's that for time? 8 minutes past 8. We're almost spot on. All right. I know we said we finish at 8, so if there's anyone that needs to carry on with the evening, you're more than welcome to leave us. It was awesome to have you. But if you've got some time, I'm going to load up some questions that I'll share on the screen, and we can work through a handful of them if you want to stay around. Otherwise, we are recording this and we'll be uploading it to YouTube as well. I see we have a hand up. Go for it.
Thank you, Darren. Mine is on settlement agreement, as you have indicated that if parties agree in terms of how they want to settle their assets, they can tender it to the court, and then their divorce can be agreed in the regard of the settlement agreement. You mentioned that settlement agreement has more power than an antenuptial contract. So we can have an antenuptial contract in place, and then when we divorce, the settlement agreement takes precedent. Did I understand you correctly?
Yes. So in your antenuptial contract, you might have something that deals with this. But if you do a settlement agreement, it would trump your antenuptial contract. But obviously, the settlement agreement requires both parties to consent to it. So it's not a unilateral thing. Both parties have to agree to whatever's in your settlement agreement to proceed with. So that will trump any other matrimonial system that you've got in place, including an antenuptial contract.
All right, thank you very much. Covered.
Awesome. Last note on the settlement agreement is the settlement agreement is just to help the parties dissolve their marriage in an amicable way or in a way that they feel they want to. So even if an antenuptial contract might give one spouse more rights with regards to certain assets, that spouse might decide, you know what, I'm not too worried about it. I'll give you whatever you wanted, or we may want to split it slightly differently than what was in the antenuptial contract. So having that settlement agreement just gives more freedom, I suppose, or more options available to the spouses in how they want to end their divorce. So it's not like it's stuck in concrete that they could only use their antenuptial contract, but obviously it requires consent from both parties. They've got to agree to it, sign it, and then obviously it will then come into force. But so are there any more questions with regards to what we covered tonight? You can anything from beginning to the end. Otherwise, we can maybe jump into some questions. All right, it looks like we don't have any other questions. So let me just pull up and share my screen. Let's get there. All right, I'm just sharing the question now. It should come up on your side. If you can just maybe give me a thumbs up when it is displaying on your end, we will start with the question. Ah, awesome. All right, so our first question is, and we've just covered this particular section. I'm just going to read the question out in case there's anyone who's listening on earphones and isn't necessarily able to watch their screen. But the question says that John and Susan are divorced. They have a minor child, Bob, and both of them are guardians of Bob. Susan wants to apply for a passport for Bob. Who needs to consent? So our options are the family advocate. Option 2 is no one. Option 3 is either John or Susan. And option 4 is both John and Susan. So we've just covered this now with regards to consent. And hey, Kundai, how are you doing this evening?
I'm doing great, thank you.
Oh, that's awesome. Wait, but before you start, how confident are you with tonight's answer?
100%
Are we going to
confident.
change your mind?
No, you're not. You guys are not changing my mind.
All right, which one do you think it is?
I'm going with both John and Susan. D.
All right. So we've got one for D. Who else wants to try it out? I don't know, Sean, if maybe you want to take the chat and then see if who's voting what there. Otherwise, if you guys want to chat, you are welcome. Put your hand up, and then you can give us what you think the right answer is.
Yeah, no, D is the undisputed heavyweight there in the comment section.
Sure. All right then. Well, you guys are all right. It's option D. But now for an extra gold star. Who knows why it's option D? Does anyone brave enough to posit a reason as to why they say it's option D and not any of the other options? Go for it. Just unmute your mic and you can let us know.
I think
Evening.
because they both have the parental responsibilities, since they
Yes.
are biological parents.
Spot on. So they both need to consent because they're both guardians and have parental rights and responsibilities. So exactly, spot on. I see we have another hand up, Irene. What you got for us?
Hello. I was just going to say because nobody got the sole guardianship. That's why they both have, they both,
Yes.
nobody is owning the guardianship.
Yep, no, 100%. Because there is no sole guardianship, both parents do need to consent. So yeah, so all those in the D camp, overwhelming majority, you guys all got it right. And we've got 2 people who got an extra gold star because they knew the reasoning why. Awesome. Let's try the next question out. All right. So co-holders of parental responsibilities and rights must seek the assistance of blank when they prepare a parent. Remember what we said about parenting plan. So our options are A, a family advocate, the High Court or the Regional Court. Option B is an attorney, a family advocate, a social worker, and a psychologist. Or option C is a family advocate, social worker, psychologist, and lastly, a family advocate, the High Court, the Regional Court, and the studio. That's quite a panel of people. Libehang, we see your hand up there. Which one do you think it is?
I'll go with A, family advocate, the High Court or the Regional Court.
All right. Who else we got? Sure. Pamela.
Yes, I think it's C, a family advocate, a social worker, and then a psychologist.
All right. We got an A and we got C so far. Kundai, what have you got for us?
I'm going with option C, family advocate, social worker, and a psychologist.
Psychologist. Oh, perfect. All right. Melindy? Linda, you'll just have to unmute your mic before you talk. All right, I think maybe might be having technical difficulties. All right, so how's it going there in the chat? Who's got the option? Are they going for A or C?
C is winning overwhelmingly in the chat, but Irene is there with B, quite lonely, but
Sure. Sometimes you got to be
yeah,
brave.
C wins, seems to be winning.
All right. So this was the one, actually was our last point that I made tonight with regards to a question that pops up. And this is that exact question I was talking about. So in this case, option C is the correct option. You need to involve either a family advocate, a social worker, or a psychologist. So if you remember anything to do with parenting plans, just remember that option C is the correct one in this case. Right, let's see what's our next one. Ooh, well, which one of the following responsibility rights does not fall under care as defined in the Children's Act? Now we're finding the one that does not. So in other words, there are three options that are true and one that is incorrect. Now options are A, maintaining a sound relationship with the child. Option B, guarding the child's behavior in a humane manner. Option C, administrating the child's estate. And option D, safeguarding and promoting the child's well-being. Now, if you ever get a situation like this where you can't quite remember what it was, or the answers are all very similar, eliminate the first one or two, and then the last two that are remaining, you can then take your best educated guess from those ones. I see, Sophia, sure, I can't pronounce your name. I don't want to mess that one up. What is your answer for this one? What do you think it is?
I think it's C. I'm gonna go with C.
Okay, so we got a C. Kundai, what do you think it is?
I do support the previous speaker with C, according to Section 1 of the Children's Act, Section 1, subsection 1.
All right. So we got 2 for C so far. Anybody else want to try a gander at it? Oh, yes, Nampelo.
I'm going to, it's actually Nompumelelo. Sorry
No,
about that.
Nampomela. Hey, no, you've got to help me here, eh?
No problem. I'm going to go with B, guiding the child's behavior in a humane manner.
Cool. So we got 2 C's and a B.
Do you mind reading the question again? It does get tricky with some wording, some part of the wording. Maybe repeat the question. But I still stand with C.
All right, we're not going to change your mind.
No, you're not.
All right. Okay, so the question is, which one of the following responsibilities and rights does not fall under care as described in the Children's Act? So the key thing with this one is does not, and they've given us 4 options. So if you're ever unsure, we know that there are 3 right options and 1 incorrect option. Knock off the 2 that you know are right in this case, that fall under care, and the last 2 that you're humming and hawing of, and maybe out of the last 2, take your most educated guess and go with that. Lebehang.
Yes, Darren, actually, I'll go with C, administering the child estate, because A, B, and D, they are the child's best interest.
All right. I like your thinking with that one.
All right.
All right. Going once, going twice. Any last minute takers? Once and 3/4. All right. So the correct answer is actually option C, administrating the child's estate. That does not fall under care. As Lebang was saying there, all the other options deal with the child's best interest. So for instance, maintaining a sound relationship, guiding the child's behavior, safeguarding and promoting the child's well-being. All those 3 fit together. The odd one here is the administrating the child's estate. that would actually fall under guardianship. So guardianship has to do with the patrimonial side of looking after the minor's estate. Right. Right, that's an interesting one. So Mary and John enter into a civil marriage. So we're going back to last night now. Neither of the parties nor the priest who solemnized the marriage is aware of the fact that the parties have a common ancestor within the first degree of consanguinity. What is the nature of such a marriage? So our options are it's voidable, it's valid, it's putative, or it's void. And I actually had someone who messaged me this afternoon with this particular question as well. So I think it's actually a very apt question. Go for it, Kundai.
So I think it's a void marriage. Yeah, I'm gonna go with void.
Okay, awesome. So void is option D. Okay. Non-Pamela? Did I say that right?
Yes, it's right. I'm going to go with putative marriage.
All right, that is option C. So we've got an option D and an option C. How are we looking over there in the chat? Who's got which ones there? Who's the winning bet?
Let me observe the chat quickly. Is it C? Seems to be
winning.
Yeah, C seems to be winning, but it's definitely not undisputed. Tshireletso says D, Marupeng says B, and who else says a different answer? Mokete says D as well. There's an A, Ribuya, and Ribuani also says D. So there are a lot of opinions on this one.
Sure, it's across the board. And it's actually a very, very tricky question when you read over it the first time around, because you have the sort of knee-jerk reaction of, oh, I know what the answer is. But this is actually one of those very tricky questions. So the correct answer for this particular question is actually answer C. It is a putative marriage. And the reason we're going with that option, because technically this is a void marriage, because they are within that prohibited degree of relations. However, the reason in this particular case that the answer is putative is they say that neither Mary nor John nor the marriage officer are aware of it. So because they're not aware of it, that makes it a putative marriage, because a putative marriage is a marriage in which one or both parties are unaware of a defect. In this case, it's both parties and the marriage officer unaware of the defect. So for this particular question, although the marriage is void, it is actually a putative marriage because they don't know yet that it's a void marriage. Now, obviously, the moment they discover that there's this prohibition with regards to that first degree of relations, then it would go from a putative marriage to a void marriage. But until they discover that defect, it is a putative marriage. Does that make sense with this? I know this question is, the wording is sort of like a catch-22 type question, but the particular answer for this one is putative. So we've got to be careful of this come Wednesday, because they might throw a couple of these types of questions in, and we'll just have to like read it over 2 or 3 times before we jump in. Because the first time I read this question, my knee-jerk reaction was it's a void marriage because it's within the first degree of consanguinity. But then when you reread the wording, you actually see that, hey, no one knew about it. So it's actually a putative marriage. So yeah. But then again, we all law students, so we don't expect it to be easy. You know, we like the technicalities.
Well, it'll be a good thing for no one to tell Mary and John.
Yes, guys, please do not tell Mary or John. They're having a blissful life now. This would really ruin it for them. All right. Okay, yeah, now we got a divorce. Okay, so upon dissolution of a marriage out of community or property, which is subject to the accrual system, the spouses share in the blank accumulated during the subsistence of the marriage. And our options are A, the assets and profits, option B, the joint estate, option C, the separate estates, or option D, the liabilities or debts. So what I'll do is I'll give you 1 gold star for the correct answer. Another gold star if you can tell me what type of a marriage system they have. So anyone want to take a stab at this? Yes, Lehang.
Yes, it's A, assets or profits.
Okay, so we've got an A. Are you going to go for the gold star as well while you at it?
So what was the second question?
So the second question is, what is the type of a marriage that they've got?
They are in out of community of property.
Ah, there we go. Sometimes we jump over that one and we just straight to the next one, but at least you read the full question with there. So you got 2 stars now, 1 star, 2 stars. I think you got the previous question right as well. So who else has got their 2 cents for this question? Which one? A, B, C, or D? So far we've got an A.
I'm going with A as well.
Nope, we got 2 A's. Any last under the hammer answers before we reveal the right answer? Going once, going twice. All right, option A is indeed the correct option. Marriages that are out of community are property and subject to the accrual system, only partake in the profits, never the losses. So all those in the A camp, yay, you guys got an extra gold star. Ooh, some calculations. All right, so this is taking us back to the accrual. All right. Okay, Mr. and Mrs. Botha are married subject to the accrual system. They are getting divorced. During the marriage, Mrs. Botha inherited 100,000 Rand from her mother, donated 100,000 Rand to her father, and received 100,000 Rand for the loss of income and 100,000 Rand for pain and suffering. Which one of the following amounts reflects the value of assets that are not forming part of the accrual in Mrs. Botha's estate? So we've got to now choose a value that will be excluded from the calculation in the accrual. Our options are A, 200,000, B, 400,000, C, 100,000, or D, 300,000. So who wants to try this one out? You go for it, Conde.
Okay, so I'm going with where am I? Option D, 300,000 rands. Because, do you mind if I explain? Sorry.
Yeah, you must go for it. There's an extra gold star on it.
Okay, awesome. Because we're looking at the non-patrimonial damages, and those are usually excluded from an accrual calculation, which are your pain and suffering, your inheritance, and donations.
All right.
Yeah, I'm done.
Exactly. That's explanation spot on. Who else wants to see how much it is? We've got option D. We've got 300,000 so far. Sure. Sounds awful quiet now. Hey, don't stress over calculations. Calculations are easy. This is easier than SCL.
Sorry to cut you off.
Yeah.
May I say something?
Go for it.
Okay. Oh, okay, no problem. The thing is, I'm using my phone to read this question, so I thought I missed something, but no, I'm okay. Thank you. Sorry.
No worries. Nompumelelo?
Yes, I would like to go with option A in terms of the calculations. Like the amount is 200 is what I would like to.
All right, perfect.
I agree with Nompumelelo with 200 Rand. Oh God, I am so out of it today. Sorry.
Nompumelelo, do you want to explain why you got to the 200,000?
Yes, because it's from the donation of the 100,000, and sorry, my screen's a little bit messed up, so I'm just trying to look
No problem.
at where I got the other 100,000 from. Um,
In-
and the 100,000 inheritance from the mother.
Okay, perfect.
Can I help
Now,
out Nompumelelo, please? Sorry.
Yes, please help me out because I can't see the full screen properly, so I'm just
Same
trying to.
here. I understand what you're going through. So it's the inherited money from her mother, which is the 100,000, and the 100,000 received for pain and suffering, because the donated 1,000 rand went to her father. She donated the 1,000 rand.
yes. Nope, spot on.
Thank
So yes, so you're both right there. The answer is A, it's 200,000. And as you mentioned, the reason it's 200,000 is the accrual doesn't include inheritances or donations that are received or non-patrimonial damages. And she obviously received 100,000 rand from her mother, which is an inheritance, so that's not part of the accrual. The 100,000 rand that she gave to her dad doesn't count because that was given to somebody else. She received 100,000 for loss of income, but that's a patrimonial damage, so we can't include that. And then the 100,000 rand that she received for pain and suffering is a non-patrimonial damage, so we do include that one. So spot on for everyone who said option A, it's 200,000. It's because of the inheritance from the mother and for the money she received for pain and suffering. Hey, there you go. You guys are spot on. Let's see. Oh, no, this looks too easy. Right. So, which one of the following events does not terminate the duty of support of a parent towards their child? So, our options are A, the child's 18th birthday, B, the child's marriage, C, the child's death, and D, the child's adoption. Now, we did discuss a couple of these ones. This is a sort of a red herring because they've got two possible options, but only one of them is an actual answer. Who wants? Oh, I see your hand is up, Kundai. Do you want to let us know what you think it is?
So you mentioned how there's two possible options, which are A and B, that being the child's 18th birthday and the child's marriage. So with the child's marriage, if she is or he is married to someone that's able to support them, then the duty of support from the parent can be terminated. And then with the 18th birthday, it's not really a conclusive decision. It's not really a conclusive scenario because he might be 18 years old but unable to support himself. So I am going with option A.
Option A. All right. I like your explanation. It was very thorough. So we got an option A. Nompamela?
I'm going with option A for the exact same reason. Turning 18, you might still be unemployed and still be needing support from your parents.
All right. That's perfect. Who else? We've got four options. We've got two so far that are on A. I'm not sure how the chat is looking on that side. Do we have any clear leaders perhaps on the options?
Yeah, no, A is almost unanimous, but there's a brave colleague here. Let me check who it is who says it's B. Specific. Because I think there are two specifics.
Right. Right. So the answer in this oh, we had a hand shoot up very, very quickly. Go for it. What do you think the answer is?
I think the answer is D.
All right. Why do you say the option is D? Do you have an idea more or less? You don't have to, but if you have a reasoning for it, it always helps other students as well.
Yeah, because if the child is adopted by other family, the responsibility of looking after that child falls to that adopted family.
Okay, yes, I understand what you're saying. Yes.
So
Right.
I think the option is D. If somebody is 18, if that person can be able to look after him herself, he can be taken care of.
All right, yes. Cool. I understand where you're coming from. All right. So we have anyone else that wants to like slide in under the hammer before we reveal the answer? We're going to like going once, going twice, 6 and 7, 6 out of 7, 7 nines, 8 tenths. All right. All right. So the correct answer for this particular question is actually option A. And I'll explain why, as Kundai and Nomapelo were explaining there. 18, when you turn 18, doesn't necessarily mean that you are able to look after yourself. And the reason it's that particular answer is the question asks what doesn't terminate the duty of support. So the previous speaker there, she is spot on if the question was asking what does terminate the duty of support, because a child's adoption will terminate the duty of support. However, this particular question is asking what does not terminate the duty of support. So it's actually asking for that negative. So the child's adoption will terminate the duty of support. The child's death will terminate the duty of support. And the child's marriage, as Kundai was saying, generally the duty of support. However, if the child can't support themselves, they can always go back. But out of all these options here, the only one that really won't terminate the duty of support is turning 18, because there's no age limit, so to speak, that's placed on the termination of maintenance. If they'd said self-supporting or self-sufficient, that would have been good. But in this case, nearly turning a certain age doesn't necessarily end that duty of support. But yeah, that was a little bit of a red herring there, because A and B were both possible options. But in this particular case, option A is the correct option. Ah, interesting. Okay. So if spouses are not divorced but no longer share a joint household, continuation of the duty of support is determined by. Our options are A, the Divorce Act, B, guilt of the spouses, C, unjustified enrichment, or D, the Matrimonial Property Act. Now, if this was an exam, you're not sure of the answer, remember, knock off the two that you know definitely can't be right or are obviously not right. And then out of the balance, what do you think is the most probable answer? Do we have any takers on this particular question? Yeah, let me have.
The chat is already flooded with D.
Option C.
Right, so
Unjustified enrichment.
All right. So we've got one option C here. Sorry, Sean, you were saying on the chat we had, which one was flooding in?
D, overwhelmingly, but there is one A.
We've got a brave A.
Yeah, and this A is very brave because they're always brave.
All right. So the chat, we've got a whole lot of D. Kundai, what do you think it is?
Okay, so honestly speaking, with this one, I'm taking a wild guess. I'm gonna go with option A. I was really hoping Nompumelelo would raise her hand first, so I would tag along with her, but she didn't. So here's my guess. I'm taking option A.
I think she's waiting for you, and she's going to tag along with your question. Now watch, her hand's going to go up.
Hi. With D. The
All right,
reason I'm going with D is when you read the sentence, it says if the spouse are not divorced. So I think if they are not divorced, they're still and they're still married, and then they're not. It's just that they don't share a joint household, but they are still married. So I think the matrimonial property will be the one. The duty of support will be determined by the Matrimonial Property Act.
All right. I like your explanation. It was well-founded. Awesome job. Melindy, what do you think it is?
Hi, Darren. It is D, and Nompumelelo has covered it correctly. It's the Matrimonial Property Act.
Okay, awesome. So there's another D. And then we've got, I don't know how to pronounce your name. Is it Wayo? I'm not sure if I'm pronouncing that right.
Yes, no, it's a while. Actually, my first name is Eddie, so you can call me Eddie.
All right, nice to meet you, Eddie. Which option do you think is the right one?
No, I would also go for D.
And your reasoning being?
The reason is that the spouses that are not divorced yet, they're still married. So even if they said they're no longer share a joint household, but they're still governed by the Matrimonial Property Act because they're still married.
No, I like your explanation. All right, so the correct answer in this case is indeed option D. As quite a few of you mentioned, they are not divorced yet, which means the Divorce Act doesn't come into play, and it will be the Matrimonial Property Act. If you were in the exam and you weren't sure about the options, what pops in my mind, first of all, options B and C don't seem to really fit in because they want to know what is it determined by. So guilt and unjustified enrichment, to my mind, wouldn't be two options that I would consider first. So I'd knock those ones off, which leaves me with options A and options D. And here again, I would take a logical approach, as a number of you have mentioned. The Divorce Act applies to divorces, but our question specifically says they're not divorced, which means we're left with one option, which in this case would be the Matrimonial Property Act. So just keep knocking off answers until you get to what you would think is the most logical response. Yes, Irene, what do you have for us? You can unmute your mic, Irene. Hold on, it's showing up. All right, you can try and mute your mic now and
Okay,
talk.
I'm here.
Oh, yay.
Okay, Darren, I think I really struggled with this one in the mock exam, but the correct answer in the mock exam, actually, it's A. I'm gonna go through the mocks and then maybe I can find it and I'll send it to you. In the mock exam, they marked me wrong for D, and then they said actually it's A, and I tried to justify it on my own, but they kept on saying it's A because I've been doing those mock exams several times. So I'm gonna check it again, and then I'll send it on the group just so that we all know which one is the correct one.
No, 100%. Drop me a message on our WhatsApp, and then I'll just I'll go later this evening when we finish. I'll just go and look up in the question bank to see if there's a duplicate of this question or if there's been a clerical error, and I'll go and have a look at it because it shouldn't actually be A. The correct answer is D. But thank you for bringing that to my attention. If you can just drop me a WhatsApp message just to remind me, I'll go and double check the question bank to make sure that it does have the correct answer.
Thank you so much, Darren.
Awesome. All right, I think this is our second to last question that I've got for us. This one says that the courts increasingly expect of women to take up employment after divorce and grant employable women. Now we're talking about different types of maintenance, what we spoke about first. So the options here is A, it's a lump sum maintenance. We've got B, it's a permanent maintenance. We've got C, which is rehabilitative maintenance. And we've got D, which is token maintenance. Nompamela?
I'm going to go with option C, rehabilitative maintenance.
All right. And are you going to leave Kundai to come up with the reason as to why it's option C? Because you guys seem to be like on a team here.
It's not intentional, but I think because the courts are increasingly expecting women to take up employment after divorce, rehabilitative maintenance speaks to the fact that if you're within a certain age, you can still be employable, you can still find employment and be self-sufficient after divorce.
Yep, I like your reasoning. Awesome. AD, I see you got your hand up. What do you got for us?
Yes, no, I'll go again for the same C.
All right. And you're going to give us your reasoning, or you're going to say, oh, no, the same as the previous speaker?
No, the reason is I can't remember the case says that they give the reasons that I would like to give about. It was said that some other spouses, they could ask in the divorce proceedings for rehabilitative maintenance, citing that they're not working, they've been not working, but after investigation, they found that they've been not working deliberately, but they're employable. Others have got qualifications. So the court, in some other cases, they did say that after divorce, if the spouse is employable and have got qualifications, then they can be actually directed to say they have to find employment.
Yep, no, spot on. That was indeed, I know which case you're talking about, and yes, spot on. Did Shego, I'm not sure if I'm pronouncing your name correctly there.
Yeah.
What do you think it is?
It's always my surname, and then my name is Olga.
Oh, Microsoft
Okay,
just swapped it around.
This question, I'm caught between C and D, but the reason for me to be caught in between is that I just need an understanding of what is the token maintenance. And then when you say rehabilitative maintenance, what is it? Because with me, I'll say token, but I'm not sure what, as to between these two, if I can get, maybe if you can just explain or just give me a clarity, like as to when you talk of a token maintenance, what is it? And when you talk of a rehabilitative maintenance, what is it that we're talking about? Because I'm caught between these two, C and D.
All right. All right. Before you let us know what you're thinking, Kundai, let me just take a minute just to explain these ones quickly. All right. So for those that missed the first section where we were talking about maintenance, a lump sum maintenance is where you'll get all the money up front in one go. And so instead of smaller amounts, you get one big chunk of money. That would be your lump sum maintenance. It's a once-off big sum of money. Permanent maintenance would refer to where a person gets maintenance continuously, basically for the rest of their life, hence it being permanent. Rehabilitative maintenance is maintenance that's paid over a specified amount of time to help a spouse get on their feet and to get themselves trained or educated or to find employment. So it's very much a short-term maintenance just to help the spouse get up and become self-sufficient and self-supporting after the divorce. And token maintenance refers to where a small amount is placed as a maintenance value, either because the maintenance isn't needed right now, or the maintenance debtor, i.e. the person who has to pay it can't afford to pay it right now, so they'll do a token maintenance. And the reason they do token maintenance is if a maintenance order is not made when the divorce is finalized, you can't come back afterwards to claim maintenance. So what they do is they put a token maintenance in for 10 Rand, 50 Rand, 100 Rand, whatever it is. It's a small amount of money, just so that in the future, when the financial position changes of the maintenance debtor, they can then increase that maintenance amount to a level that it was originally perhaps supposed to be at. So that's what token maintenance is. So those are the four different types of maintenance. I'm not sure, Kundai, if you want to let us know what you thought the answer was, or if you have perhaps an easy explanation of what rehabilitative maintenance is for the other speaker.
So yeah, I don't have much to say, but when it comes to option C, rehabilitative maintenance, I think it would be easier if people just try, well, for the sake of how quick how around the corner the exam is, when we look at rehab, you're given another chance to start over, right? You're given another chance to better yourself. And with the aim of rehabilitative maintenance is to help the recipient become self-sufficient. So you're given another chance to start over again. So this amount is probably there to help you get back on your feet, like coming out of rehab. Yeah, just that.
No, that's spot on. I think that's a much easier definition to digest than my very long wordy one. So yeah, that's definitely spot on. All right. So any other final takes on this question before we get to the answer? Any last hands want to shoot up? Going once, going twice. Yep, and it's closed. All right, so the correct answer for this question is indeed C, it's rehabilitative maintenance. As Kunda was saying, it's just to help you get on your feet and become self-sufficient again. So in this case, to help the woman become employable. And our last question for tonight, oh, looks like an easy one, or a very short one at least. The question is, a maintenance order in terms of Section 7.2 of the Divorce Act comes to an end. Your options are A, on the remarriage of the maintenance debtor, B, on the date stipulated by the maintenance recipient, option C, on the date stipulated by the maintenance debtor, option D, on the remarriage of the maintenance recipient. Just to help you along here, remember that Section 7.2, a divorce settlement under that subsection, has a statutory foundation. In other words, it's a court-ordered settlement. All right. Kunai, what do you think it is?
Am I audible?
Yes, we can hear you.
Okay. So I'm going with on the remarriage of the maintenance recipient. Because, okay, no, I'm not going to explain. Maybe I'll give the others a chance first. This is our last questions, right?
Yeah, this is our last question for tonight. All right, Melindy, there you go. The floor is all yours. You can give us your what you think the answer is and your perhaps your reasoning as to why you think that's the answer.
Hi, I think the answer is B. I'm caught between B and C. I don't think it's on the remarriage unless the settlements or the order would have, the divorce order would have been clear that the maintenance would come to a stop when the other spouse either cohabits or remarries or moves on with their lives. But if it was not part of one of the clauses, I don't think it can then be introduced later on.
All right. Anybody else have, well, I see Kundai, your hand is back up again. What you got to add for us? Oh, no, the hand disappeared.
That was a mistake. Sorry, guys. Sorry.
I thought you were coming to rescue us here. Oh, and AD, your hand went up and down. Hey, guys, come on now. I'm watching. I'm like an eagle. Yeah, I saw that. All right, Maripang, what do you have for us?
Or do I need to come in?
Yeah, go for it.
Okay, no, I'd go for D.
Option D. All right,
Yeah.
perfect. We've got D there. Anybody else who wants to let us know what they think the option is?
I wanted to provide the reasoning behind D.
All right.
To indicate that the remarriage of maintenance for the recipient is one of the grounds for termination of maintenance. So once the recipient remarries, automatically the maintenance falls out.
All right. How's it going on the chat there, Sean? Is there a clear winner, or we got a couple of brave answers out there? Ooh, very quiet. Let's see. Sure. D, sure. D, D, C. Well, it seems to be coming down to those two again. All right. Before we go to the answer, any last hands going to shoot up before we do the answer? Going once, going twice, 2 3/4, 2 4/5. Okay. Right, the correct answer in this case is option D, on the remarriage of the maintenance recipient. And the reason being is that the divorce settlement is under Section 7.2 of the Divorce Act. And if we remember, Section 7.2 is the statutory foundation. So there's prescribed time frames of when it comes to an end. And under 7.2, it's on the death of the recipient or the remarriage of the recipient. Now, one of the speakers there was talking about the settlement agreeing to allow it to continue or not. That would work if it was under 7.1. So subsection 1 would cover that. That's where there's a settlement agreement between the spouses and they come to an arrangement. That in that case, then that it would decide, does it come to an end or it doesn't come to an end. But because we're talking about section 7, subsection 2, it's legislated that it comes to an end on remarriage or death. So if you get a question like this in the exam, just remember there is a difference between a 7-1 and a 7-2. 7-1 is a marriage settlement where the parties agree on it and they make their own terms and conditions. And a 7-2 is where it's legislated in law how it comes to an end. All right, guys, I'm not sure if there are any other comments or questions or if anyone wants to have a say about something. We'll run like a marriage. All right, guys, are there any objections or does anyone want to have anything to say or forever hold their peace? Sure, it's quiet.
Oh,
Go for it, Eddie.
Actually, I wanted to find out to say that sometimes in the quiz questions, you find that you can have two correct answers, but the system, they need the other answer. And in that case, what is one supposed to do? And on your side, what do you do? That if you happen to say that the answer that I got, it was the correct one, but in the system, there was something that was given to the system. I just wanted to understand in that situations what one needs to do.
All right. So with regards to, I'm assuming now we're talking about the mock exam site. So when I initially loaded all those questions up, I was obviously relying on somebody else putting the answers in as well. And we have like 250 something odd questions for the PVL module. So there's a lot of questions in there. And it's not impossible that there might be a clerical error. Perhaps, when we're loading the questions on, the incorrect option was selected or something along those lines. So it's not impossible that there will be a question with an incorrect answer. What I have been doing is I've been going through the question bank over the past week and I've been personally verifying all the answers. So you'll notice that you'll get some questions where there is what they call a combined feedback, where it'll actually tell you the page number, the legislation number, and in some of them I've even put the calculation. So like when we're talking about the accrual, I've actually typed out how to do the calculation, so on and so forth. So all those questions you'll see I've verified the answer for them. So the goal being to try and eliminate any clerical errors or mistakes. So if you do see one where there is a mistake, please do drop me a WhatsApp with the question or a screenshot, something along those lines, so I can go and look it up in the question bank, and then I will verify the question if it's got an incorrect answer or not, because it's not impossible that it may have an incorrect answer. So I'm assuming you're talking about the mock exam site.
Okay, no, thank you. I got it.
Okay. Perfect. Yeah, I encourage you guys, if you do find errors, as I say, there's like almost 300 something questions, 250 plus questions in this question bank. I've been trying to work through them, but obviously it does take time to look the information up in the book and do that. So I'm about just over halfway at the moment. So I've still got like another 100 and something questions to go through. So if you do see a mistake, do let me know. It does help me fix them. Maraping, what questions do you have or any comments?
How do we get hold of the mock trial questions? Because I see colleagues have that information, and I personally believe these are questions which will greatly assist in terms of preparations. Is there a link or site which one needs to visit to gain access to this information, or is there a particular route?
Okay, so it's just a website that I've set up with all these questions. So the questions that we've been going through tonight are screenshots from that website. It just runs different quizzes in that. Let me just pop over to the chat, and what I'll do is I'll drop the website link in there for you. You can go through to the site. The site's 100% free to use. The only thing is we ask that you create an account on there. It's how I keep the spammers and the trolls and everyone out of the website so they don't cause problems. You just sign up using your UNISA email address, and that's pretty much it. I'm just going to quickly drop the link in the chat for you, and then you can go and have a look. But otherwise, if you have any problems, you can just drop me a message and I'll help where I can. All right, I've just dropped it there.
Cheeky.
All right,
Yes,
so
thanks.
Okay, so it should be there, and you should be able to click on and go straight through. All right, we've got a couple other hands up. Nompamela.
Yes, thank you very much. I just wanted to say thank you for your time. And I wanted to ask, we will be having another revision session, maybe like tomorrow or something like that.
We haven't planned one for PVL. This is the second one already, so we just split the book in half. We did half last night and half tonight. So we haven't planned any more specifically for this module. From this point onward, we would probably only be focusing mostly on past question papers. So all these quizzes that we're going through themselves, unless there's a particular point or something in the prescribed book that you're not sure about, we can maybe do something, a very brief session for that. Otherwise, it's just purely coming back down to practicing these quiz questions.
Thank you. And one more question, please, that I wanted to ask. Is this the only module that you're having these revision sessions for?
We do for different modules. It just depends on time and what we have available. So we have been doing, for like instance, constitutional law, entrepreneurial law. We've done for a law of persons and so on. So we do try and do them for different modules. If there's a particular module you need something for, just drop me a message on WhatsApp and I'll see if we have time or we can slot it in. But we do try and do it for as many modules as we can. We also record these sessions and I post them up on YouTube. So you can go through to the YouTube channel. And if, for instance, you missed last night's session, you can go back and listen through those as well. And so we just post everything up as well in case you do miss something. But if there's a particular module that you would like us to do some prep work for, do let me know. And then if we have time, we'll see if we can include it.
If possible, and if you do have the time, I would have loved some assistance with the PVL 201, or is it 202?
Well, this one is the 2601 family law. 2602 is the law of succession.
Yes. If possible.
Right. I think the PVL 2602, the exam, I think is in a week and a half's time, about 10 days or something. We'll look and see if we can have something for that. If we can, I'll pop it on the WhatsApp group and let everyone know.
Thank you very much. Thank you very much.
Cool, 100%. Olga, I see your hand is up.
Oh yeah, I wanted to support the question that was raised. I'm not sure whether it's Eddie or who, with regard to the questions that are on mock exam, and you'll find out that when you press, let's say there's a one of Miss Botha, name Mr. and Mrs. Botha. It says they are married in community of property. And then which of the following assets can be forfeited by Miss Botha and all that. So there's 4 questions, but 2 of them, they're the same. Like the house that Miss Botha brought into the joint estate. The number B is the same thing. So like when I tick number B as my correct answer, but when the feedback comes, it's the same answer, but on the mock exam, it says it's incorrect. But the feedback is the same answer.
Yeah, so that's obviously a clerical error if there's 2 answers that are the exact same wording. What happens is on the site, when we select which one is the correct answer, there will be 4 options and we have to choose option A, B, C, or D. And we have to then say, right, this is the right option or the wrong answer. And the system doesn't really worry about what the wording is. It's only looking at which one we've selected. So if there's 2 answers with the same wording, it'll be a 50-50 as to whether you get it right or not because of the way it's marked. What I'll do is, you mentioned it's Mr. and Mrs. Botha. I'm just going to make a note of that so I can go on the site and see why there are 2 answers with the exact same wording. There shouldn't be. So thank you for letting me know. I'll go and have a look at that. And if you find any others like that, do let me know. As I say, sometimes when we're trying to upload these things in a hurry, we sometimes skip over some of those. But let me go and check that out and I will correct that, that question.
Okay, thank you.
Yeah, so do we have any other questions or comments or anything along those lines before we close for the evening? The YouTube name, so the YouTube name is Darren88. I didn't know what else to call it, so I just created the account just to upload some videos and I had no idea. And YouTube said, this looks like a good name. And I was like, sure, that's a good name. Let me drop it in the chat there. So if you go to Google and you type in YouTube and you type in Darren88, it'll pull that up. Let me just see if I have the link. I should have the link here with me now. I'm just trickly. I'm just quickly trying to grab it for you, and then I'll post it in the chat. There it is. All right, I'm posting the link in there now. So that's the direct link to the YouTube channel. So this video, when we finish tonight's evening, I will process it and then upload it to YouTube. So it should be available within about half an hour or so of the meeting ending. All right. I don't know. I think if that's all the questions or anything, I think we'll call it a night. I hope it was able to help. I see your hand, Sean.
Okay, before you leave,
Yes, Darren. Just on a closing note for future classes that we might have, housekeeping, because you also did mention earlier, with regard to switching off cameras and muting mics. Guys, I'm very fragile, so it's very hard on my conscience when I have to switch off someone's camera. I won't sleep for a week when I have to switch off your camera. So please cooperate with me and don't put me under such heavy moral predicaments. Let's keep housekeeping in mind. Thank you very much.
Yep, that's very important. It just helps us keep very organized and running smoothly. There was a person who had their hand up. I'm not sure if you had a question. All right, so it looks like we are all sorted. All right, guys, it was fun. I hope you guys had some fun and you learned a couple of new things. But have a super evening, and I'll post this up on YouTube shortly. Otherwise, I'll see you guys over on the WhatsApp groups. Have a super evening.
Thank you. Thank you.
thank you.
Thank you.
Yep, you're welcome.